Hi everyone, welcome to the 3PB Family Law Brunch. Today you'll be hearing talks from me, Luke Nelson, and my colleague Martin Dancey. I'm a trust of land and financial remedies specialist. I'm broadly a dual focus on the civil and the family side of things. I'm talking about intervenor claims today with a focus on third-party interests in land. Martin is a recent associate member of Chambers. He was the DFJ for Dorset between 2018 and 2022. Prior to that, he was a circuit judge, and prior to that, he was a district judge. And prior even to that, he was a well-known solicitor. Martin will be talking about out-of-court solutions in private children cases, including conciliation and early neutral evaluation. If there are any questions throughout the morning about this presentation, then pop them in the Q&A box. I can see someone has asked if anyone's getting an echo, so I should probably just see if anyone in chat is going to say whether that is something that's happening. Okay. Some are saying yes, some are saying no. Okay. We're getting more no's. We're getting more no's. All right. Okay. I'm sorry, Gail, if you're still getting an echo, but at least that means you can. It adds some gravitas to the talks today. All right. Yeah. Any questions? Put them in the Q&A box. I'm the opener today, as you can probably tell from the slides on screen. So I'll go first. Martin will be headlining afterwards. So my talk today is on intervenor actions in financial remedy proceedings, with focus on TOLATA, procedure, and tips. Broken it down into 4 questions. First, is my case suitable for joinder? 2, what's the procedure for joinder? 3, what's the applicable law for dealing with third-party interests? Now, as you might imagine, there's all sorts of sort of offshoots, etc., of the law on this. So I won't be talking about every single thing. I'll be talking about the main points and some points to note. But of course, if there are any specific questions, I can address those. And finally, number 4, what can I do to run a joinder case effectively? So, is my case suitable for joinder? There are some questions that, well, there are some things to look out for. The first is when people start talking about other people being involved in the purchase of a property, third-party beneficial interests. If there's an issue with a trust dispute, one of the parties gets some of their income from a trust, but there's a dispute over how that's going to be, a dispute within the trust as to how that's going to be paid out. That's something to bear in mind. If there's applications to vary a nuptial settlement, obviously that's a fairly specific one, but that's the case whereby the trustees are almost certainly going to need to be joined. And in some instances, joining a company where it's asserted to be the sole depository of a party's wealth. Obviously, today I'll be looking at third-party beneficial interests more than anything else. So the first place to go when considering whether your case is suitable for joinder is FPR 9.26 capital B. The test is whether or not it's desirable to join the parties, and it could be one of the two. Either it's desirable to add the party to resolve all the issues in dispute, or it's desirable to add the party to resolve an issue between that party, the new party, and an existing party, which is connected to the matters in dispute in proceedings. So then what is desirable. In the case of the Welsh ministers against Price and another, tells us there are two focuses for joinder. The policy objective of enabling parties to be heard if their rights could be affected, and the overriding objective. Obviously, in family proceedings, the overriding objective is of course number one of the FPR. When considering if your case is suitable for joinder, you might want to think about whether you actually want to bind that third party to a decision. It might depend on which side you're on as to how much you want to bind the other party. But for example, if let's say you're representing husband in a case and he says, well, my mum contributed the deposit to the property and she's entitled to 50% of my share, you may want to ensure that mum is correctly bound to the decision by being joined, rather than just being invited to be joined, because otherwise, if the family court finds that, well, she's not joined, she's not got involved, and then you proceed to have a decision whereby the property is divided in a certain way, but then mum comes back and is feeling particularly vindictive against husband for some reason, asserts her interest in separate civil proceedings, you could find yourself with an order that doesn't meet needs. So that's the case there, Gorisaria and Gorisaria. A simple invitation to intervene doesn't bind a party to the outcome. That's an important thing to remember, particularly if you really need to pin them down. So on to the second question. What is the procedure for joinder? So it's a Part 18 application. You see I make reference to the practice direction to Part 18 4.6, which is that any application made pursuant to Part 18 needs to be made as soon as it becomes apparent that it's necessary to make that application. That's particularly important for joinder in financial remedy proceedings. And indeed, that point was to some extent outlined by Mr. Justice Mostyn in TL and ML. Now, Mostyn's decision, albeit we say only High Court, but I think we all know how, in what high regard Mostyn is held in the financial remedies community. But he was approved of in Goldstone and Goldstone in the Court of Appeal. So this isn't just High Court authority, it's also received approval on two occasions, actually. It's in Goldstone in another case, that this is the appropriate way forward. And the appropriate way forward is that the third party should be joined at the earliest opportunity. So that's an echo of the practice direction to Part 18. Direction should be given to issue fully pleaded points of claim and points of defence. For those of you who are more familiar with civil practice, what you're essentially talking about is particulars of claim and defence. You may also, if the case allows, or if you think it's likely, want to ask for directions for a reply, because it might very well be that the defence, as it were, raises issues that you couldn't have raised in the points of claim. Mostyn says separate witness statements should be directed in relation to the dispute itself, and then the matter laid down for a preliminary issue hearing to take place before the FDR. Now, that is the approved guidance, so to speak. You may often find you'll be considering yourself, or you may get pushback from the other side, that a preliminary issue before the FDR might be considered disproportionate in a case that's either low or modest assets. It's an argument that could cut both ways, but ultimately, my experience is that experienced financial remedies judges tend to say you may be trying to save money by avoiding that preliminary issue, but if you just can't get to the bottom of it and you go tearing through into an FDR, you're going to end up having to have this preliminary issue tacked on at the beginning of a final hearing, which is going to cost far more rather than doing the preliminary issue first. And we'll see that costs are a fairly significant consideration in intervenor cases, because, and I'll talk about this later because we've received a question on this already, that intervenor cases are clean sheet. In terms of who makes the application for joinder, that was also dealt with by Mr. Justice Mostyn in Fisher Meredith, and it really the point is, if the assets are in one party's name and they claim it belongs to another, it's upon them to join that third party. If you're the party that's arguing that in fact property that's owned in another person's name is actually owned by the other party, then it behoves you to make the application. Now, there's a fair bit of grey area in both of these procedural aspects, and I'm probably showing off my nerdiness by starting to try and delve deep into the granular detail for now. But Fisher Meredith can sometimes mean that if you're technically having to write points of claim from a Fisher Meredith perspective, your points of claim might very well be, well, the property is in these names and that's how it should be. You then have a very long, fully pleaded defence to your points of claim, which is fairly brief, which is why, as I say, sometimes putting in provision for a reply can be very helpful to fully bottom out and plead the issues in dispute. So what's the law? Trusts of Land and Appointment of Trustees Act. There are 4 main sections that you'll be concerned with in an intervenor action. Sections 12 and 13, they deal with issues of occupation of trust property and the principles effectively of occupation, rent and equitable accounting, although they don't expressly say occupation, rent or equitable accounting, as we'll see. Section 14 is the section that gives the court the power to deal with property under TOLATA. Section 15 are the relevant matters for the court to consider. Stack and Down and Jones and Kerner are the 2 big ticket cases, as it were, that sets down the law as you want to apply it in terms of common intention constructive trust, which is a beast all of its own. So, Section 12 of TOLATA, this provides a party with a right to occupy. So, this is a beneficiary who's entitled to an interest in possession in the land, is entitled by virtue of that interest to occupy the land. So, this is something that you may want to consider if one of the parties, for example, mum is living in the property. It's asserted that she's got a beneficial interest, but one of the parties, for whatever reason, is trying to push an order for sale. You can't strictly do that without an order for sale from under Section 15 if it's going to affect the rights of a beneficiary. Section 13, you're probably unlikely to be able to read right now on your computers, because it's so small, but really the essential points to take from it are these. The first is that a co-trustee can't unreasonably exclude any beneficiary's entitlement to occupy land, and they can't restrict that entitlement to an unreasonable extent. If they are going to exercise powers to remove somebody from the premises, a beneficiary from the premises, then conditions may be imposed upon them to pay any outgoings or expenses, or to assume any other obligations. Those are for the ones who are staying in the property. If you're booting them out, then you may be required by this section to make payments of compensation to the people who are excluded, and that's where the law on occupation rent comes in. If you stay in short, if you stay in the property, then you may have to keep clearing the outgoings, which is standard. And if you're excluding somebody, then they may be entitled to apply for occupation rent as well. And again, you can see how once these factors start to get mixed into a financial remedies case, particularly in such cases when you may be looking at fairly low assets or the property is the only asset, you can see how it becomes quite a significant risk for meeting the needs of other parties. Section 14 essentially is what gives the court its powers to make determinations under TOLATA. And really the court has two powers. The first is the same powers of a trustee, the exercise of their functions. So they can only do, the court can only do what a trustee could do. So it doesn't have the redistributive jurisdiction that it has under the Matrimonial Causes Act. It can only do what a trustee could. The alternative is that it can declare the nature or extent of a person's interest in the property. So that's where the court's declaratory jurisdiction comes in. And that's where the court says, well, I've decided that this property is held, for example, 50% to husband and wife and 50% to the intervenor. And section 15 is all the matters relevant in determining the applications. So that's the intentions of the persons who created the trust, the purposes for which the property is held, the welfare of any minor who occupies or might reasonably be expected to occupy, and the interest of any secured creditor of any beneficiary. There are also, depending on the case, subsections 2 and 3, which deal with other issues which I won't get into in this talk, but you'll have to consider those as well. The reality is, in most cases, the intentions of the parties and the purpose of the trust really go hand in hand. You'll often find if the intention of the parties was to create a family home, the purpose for which it's held is as a family home, and so by virtue of a divorce or a separation, the intention and the purpose has necessarily voided effectively. Welfare of any minor, it's important that it says any minor, because that doesn't necessarily mean a minor of the marriage or the relationship. It could be an unrelated minor, which is a point that you can start to have arguments about if you're having Schedule 1 cases when somebody else's child is living in the property after the parties have separated. A brief talk through the applicable law. Stack and Dowden, really, really important judgment for any TOLATA practitioners. The gist is this: equity follows the law. That's the presumption. That means that when you're looking at the title deeds, if the property says it's held in the joint names of husband and wife, then it is presumed that they are entitled to an equal beneficial interest. If you want to disprove that, and then the burden is on you to do so. So it's fairly straightforward rules of law there. In order to prove that the beneficial interest is different from the legal interest, you must prove a common intention to depart from the legal title and detrimental reliance. And I've made reference to Hudson and Hathaway, which was the recent case last year, originally in the High Court judge, Mr. Justice Carr, found that there needn't not be detriment, but the Court of Appeal towards the end of last year held, no, there absolutely does need to be detriment. Detriment's a fairly wide concept. It could be financial, it could be giving up an opportunity, and as we saw in Hudson and Hathaway, it could even be giving up a claim that isn't even really strictly a good claim. That case dealt with co-owners who, as part of their separation negotiations, were talking about sharing shares that one party had accrued, which of course the other party had no right to a share of anyway. So detriment is a fairly wide concept. Those ingredients that I've just outlined are what form what's called a common intention constructive trust. This is the main way in which a party will try to depart from the legal interest in a property. So if you act for an intervener, say your mum, in the case of a husband and wife's name are on the title deeds, then you want to be asserting that there was a common intention between you and the parties, that you would have a beneficial interest in the property, and you relied on that common intention to your detriment by, for example, paying the deposit on the property. Jones and Kernock came next in 2012. That clarified some points raised in Stack and Dowden. But there's a lot in the judgment, but I've tried to condense it down to the point of 4 bullet points. Those of you who are familiar with the case will know how well or not I've distilled it. But what essentially there are is 2 stages. You determine whether the beneficial interest differs from the legal interest. Sometimes this step is very short, because if it's a joint names case or a sole names case, that can affect how it goes, but the same test applies. And the second is determination as to what shares each party is entitled. So does the beneficial interest differ? If so, to what extent? Now, stage number 1, the court can only rely upon direct evidence or inference from evidence. So that inference can come from things like money spent on renovations, paying towards mortgage payments, etc. Oh, of course, direct evidence. There was an agreement that we would hold the property in certain ways. You cannot, in determining whether the beneficial interest differs from the legal interest, use imputation, i.e. the court can't say what it thinks should have happened. It can only determine what has happened. The court can use imputation when determining what shares the parties are entitled to, but only if they can't do so using inference or direct evidence. You can understand probably from me explaining that, however well I've explained it, it's probably a matter for how many heads are being scratched behind the cameras now. But it's a fairly fine distinction, and so it's quite an important one. If the case turns on it, you need to pay very careful attention if you're listening to a judgment as to how the judge has reached the decision on the shares, on the actual amount of share. I'll touch very briefly on express declarations of trust. This is an issue that can very often be a slam dunker, so to speak. Now, you can either have an express declaration by way of a strict trust document, a deed of separation, a deed of surrender, a notice of severance can sometimes even be an express declaration. But more often than not, when the parties purchase the property, the TR1, if the conveyancers have done their job, and I say that as a TOLATA practitioner, when we see far too many TR1s that this part hasn't been completed, there should be a little box, usually box 10, with a declaration of trust. If that box is ticked, for example, we hold the property as joint tenants or as tenants in common and equal shares, you have an express declaration of trust, and that will be determinative, at least when considering a common intention constructive trust. The case law goes all the way back to the 70s. I've outlined it in the first bullet point there. More recently in Pancania and Chandegra, which was a 2012 Court of Appeal case. I reference to look out for Clark and Midas, because this can sometimes throw people on both sides. Clark and Midas was a 2010 High Court case in which the judgment allowed a party to plead proprietary estoppel and a remedial constructive trust. Now, I don't want the difference between a remedial constructive trust and a normal constructive trust is that a remedial constructive trust has never been supported in English law. What a remedial constructive trust is effectively is a court imposed constructive trust, whereas a constructive, all the court's role is in determining a constructive trust in the normal circumstances is to say what actually happened, what the agreement was. It's declaratory. So Clark and Midas does not show that a common intention constructive trust can arise after an express declaration. It's a bit of an outlier. So if somebody cites that against you, you can hopefully now punt it back to them. But also, if you're on that side when you're trying to assert a common intention constructive trust, Clark and Midas is not the way. The only way really are, well, there are two: rectification of the deed, and that can be on the grounds of mistake, etc., some vitiating factor, or proprietary estoppel, which is why it's really important if you're acting for a party and there is an express declaration of trust to focus on proprietary estoppel. The test is largely the same as a common intention constructive trust. It requires an assurance, it requires detriment, it requires reliance. The case law for that is Thorner and Major. So I, as a matter of course, when I'm drafting pleadings in civil or in FR work, will always plead proprietary estoppel in the alternative. But in order to do that, you need to make sure there's a clear assurance about specified property. It's not enough to say, for example, he said I would never be homeless. Right, now that I've bored everybody to tears with all the law and procedure and so on, what can you actually do? What are some practical tips? Look for the signs. So it's really important. Actually, I'll start with the second bullet point first. It's important to tackle the issue early. When you're first taking instructions with your client, if they mention things like, well, mum gave us the money for a deposit, or I own this property with a business partner, but my name's on the deed, or there's reference to their siblings who are also entitled to a property or whatever, you need to bottom out the issue early on, because as we know from TL and ML, and indeed practice direction to part 18, you need to get directions in early, and really you're looking at the FDA to be addressing these sorts of issues. You need to be able to, if not be at the bottom of them in terms of whose beneficial interest is what, you need to certainly know what the actual dispute is and what the issue is, so you can effectively ask for joinder. Because the risk is, if you end up getting to final hearing or even an FDR and you've not properly considered the point, and then it's raised as an argument at FDR, what you risk is that you've done all this work up to FDR and you're going to have to essentially go back to the drawing board to deal with a preliminary issue of beneficial interest. And I wouldn't put it past some judges to say, well, once the preliminary issue is done, you can then go back to another FDR, because that was the big issue in the case. So addressing it, wrestling with it early is an absolute necessity. Ensure that your points of claim and defence are fully pleaded. As I say, they need really to be treated like civil pleadings. If you're unsure, always feel free to instruct counsel. That's what we're here for. And that is, if you can take away one thing from this talk, take away that. When you're applying your mind to the issue, always have the test in the forefront. Common intention, detriment, reliance. Apply it as you go along, because what you don't want to do is run a bad intervenor case, because your client will be at risk of costs. It's a no order, it's a clean sheet case. It's the soft costs follow the event regime per Godkovich. And so you need to be very careful. If you're going to run an intervenor case, you need to make sure it's got legs. Otherwise, you're doing your client a disservice, because they're going to get slapped for costs. And of course, somewhat shoehorning in Martin's talk topic, consider ADR outside of the court framework. Obviously, Martin today is going to be talking about the children element of it, but there's an issue of third-party interest. It's always worth getting in if you can get a private FDR on it, or a non-private FDR, but some sort of out-of-court resolution to it, whether or not you deal with it as a discrete issue before having to go through court, then that's always going to be preferable. All right. Now we've got a few questions. We'll answer these questions at the end of the session. For now, I'm going to stop sharing my slides, and I'm going to hand over to my esteemed colleague, Martin, who will be talking you through his talk. Thank you.
Right, thank you, Luke. I just need to backtrack, I think, on my slides a bit. Yes, here we are. It's jumped in halfway through. And I'm just going to shut something down. There we are. Good. Right. I think we're ready to go. I'm going to ask Luke if he can put his hand up if he can hear me. Excellent. Thank you very much. And now, as they say, something completely different. And I promise no law in this section of the webinar. I was delighted to be able to join 3PB. I retired as a full-time judge March last year, although I continue to sit regularly in retirement, including as a financial remedies judge. And the idea of joining 3PB was with a view to doing private FDRs, but also with a view to doing some children work, particularly extending what I'd been trying to do as a judge through judicial conciliation. There are two particular needs, I think, for out-of-court solutions in children cases and a solutions-based approach. You may be aware that in Dorset, we have, since last February, had the Pathfinder pilots, which we've launched alongside North Wales. But Dorset has been piloting the Pathfinder on behalf for England and hopes to roll out at some stage in the future. And that's very much a solutions-based approach. But there are, as I said, two reasons, I think, why this is so important. The first is the impact of parental conflict, and the other, the court experience. I think I'm going to hold this up. I hope you can see it. You probably can't. That is my copy from 1974 or 5 of Erin Pizzey's "Scream Quietly or the Neighbours Will Hear." This came out while I was at university, and we studied domestic violence, as it was then called, and we understood since then, for the last 50 years or more, the impact on children of exposure to domestic violence, or now domestic abuse. What's only more recently been researched is the impact on children of exposure to parental conflict. And I don't mean here the occasional argument. I'm talking about enduring unresolved parental conflict. And Harold and Sellers did an evidence review in 2018 where they looked at the research which shows that exposure to parental conflict impacts on all a child's domains. So it impacts emotionally, psychologically, physiologically in terms of sleeping and eating, neurologically, on brain development, on education, on peer and adult relationships, and so on and so on. One of the saddest aspects of the work that I had to do, particularly around deprivation of liberty, when that was still being dealt with locally, were the large numbers of young people, adolescents, teenagers, who were out of control and at very great risk, sometimes potentially fatally so, with very little resource to deal with them. But invariably, in the background, there were many reasons why these young people were where they were. And almost always parental conflict featured as a background factor. I've given you a couple of references there, and do look, if you've got time, at the Reducing Parental Conflict Hub around the Early Intervention Foundation. What can you expect to see in children, young people as they grow up, particularly around adolescence? With boys, you will find normally externalized behaviors, aggression, drugs, alcohol, criminalized behavior, joining gangs, challenging externally. Girls tend to internalize behaviors, so they'll become anxious, depressed, self-harming, suicidal ideation and action. So it's difficult to overstress the importance of this issue, which has become increasingly apparent through my time, certainly, dealing with these sorts of cases. And it becomes apparent when you deal with children and see what they're saying through CAFCAS and others in school about handling the conflict and how they manage it, because there are two stages to the impact of parental conflict. First of all, the awareness of the conflict, and the second, responding to it. And it's how children respond to parental conflict. They're divided loyalties. They're wanting to appease both parents, particularly the parent with whom they're aligned, likely to be the primary carer, which causes so much conflict between parents. It becomes a circular issue. And one of the difficulties in particular is, of course, whereas with domestic abuse and exposure to that, it's about adults on adults. With parental conflict, the conflict is about the child. And so children very quickly pick up that the reason the parents are in disagreement and arguing and shouting at each other is because of the child, because they need to go to court to sort out child arrangements and so on. Children very quickly then feel guilty, suffer low self-esteem, want to become invisible. Perhaps it'd be better if I wasn't here. And that leads to the sorts of problems I was saying with children who grow up with real challenges and vulnerabilities and risks into adolescence. Any other aspect is the court experience. What's it like for families? You will have seen this very directly with the support you give to parents and other family members in courts, and you will know that however much we like to think that the court experience is not adversarial, it largely is. Cases have to be set out, evidence gathered, statements are made, and it all becomes very polarizing and entrenching. And for parents, the court experience is alien to their normal lived experience. They're outside their comfort zones, and it's very stressful. Let me pause to say something about stress, because I think stress is a really important issue. We're all, as I say to parents, given certain resources to deal with stress in our lives. Presenting webinars is quite a stressful experience, but we hope we manage it and get over it. Work, domestic life, bringing up children is by its nature stressful. Certain things in life, though, become overwhelmingly stressful, and that can happen, of course, with relationship breakdown and loss, particularly where there are children involved, particularly where there is disagreement about the arrangements for children, and particularly when it becomes sufficiently difficult that resort is made to court. What does stress do? What it impacts on people, again, physiologically and emotionally, psychologically? You lose sleep, you don't perform well at work, you don't think well, you tend to think short term and not be able to see the long-term issues. And so for people who are in court, who are at the top end of the stress levels, they have all used up all their resource around stress, emotionally speaking, and don't have the resources available to listen well or think well or to have empathy for the experience of others. So very often parents find it, I think, very difficult to be able to reduce the stress levels to the point where they can walk in the other's moccasins for a mile, as the expression goes, to understand what it's like on the part of the primary carer, to understand what it's like being marginalized and isolated from your child, or that other parent, the non-resident parent, understanding what it's like to bring up a child as a single parent, and have anxieties and issues about time spent with the non-resident parent. And so the court experience, in my view, exacerbates the stress levels that parents have and make it very difficult for them to think rationally sometimes. And you will know this when you're trying to advise parents, getting them to listen rationally to what you're saying can sometimes be a bit of a challenge. One of the other problems with the court experience is that it's a sticking plaster and not surgery. I remember when we had the 2013-14 Making Parental Responsibility Work campaign by the former president, James Mumby, it was very much a question of getting parents into court, dealing with the issues that they raised as quickly as possible, getting them out again so that they could continue to exercise their parental responsibility. Well, unsurprisingly, 30% of the cases, the private law cases that we deal with, are returning cases. And this is one of the primary reasons why the private law working group was set up some 4 years ago, to try and improve the court experience and in particular outcomes, to ensure that families didn't have to return to court. But it's not surgery. We're talking about how much, when, where, handovers and that sort of thing, not the underlying question of relationships, which is what interests me. And the court experience also, because it is state interference, it is the imposition of a decision, is counterintuitive to the exercise of parental responsibility. You'll be aware of a very recent campaign from a number of quarters, including from the president, about the language that we use and how important it is, and how actually the language we use shapes our own mindsets and behaviors and approaches. I've for long said that, for example, the justice in family justice system is a misnomer. What you and I think of as justice, that is a fair outcome, for parents who come to court may take a very different view. I want justice, and they see it as getting their just desserts, or indeed the other parent getting their just desserts. The system is accusatory, divisive. The use of the expression Smith versus Smith, the battle metaphors, the fight, the rights, all that sort of language, dispute. When the MOJ produced its draft practice direction for the Pathfinder, it had the word dispute in it 47 times. And it took quite a battle for me to persuade them actually to take it out with a more acceptable alternative. This isn't about disputes, it's about finding solutions. There's some good articles, two good articles, or two parts of one good article by Helen Adam and others, Helen Adam, the chair of Family Solutions Group, in Family Law in December and January. There's a quotation there from that those articles. Please do look at them. Language is really, really important. So where does this come from, this idea of conciliation, and what is it? Back in 2010, I was getting pretty fed up as a district judge dealing with numerous cases of private law cases and applying sticking plasters. And I thought it would be helpful to offer to parents an opportunity to come in with or without lawyers, more often without, but sometimes with, to focus not on the how often father sees Johnny or where, and handovers and so on, the sticking plaster bits, the arrangements, the superficial things really, but on the underlying building blocks, the relationship that the parents had as co-parents, whether it was working, how they were communicating, because without addressing that, it was inevitable that parents would come back to court. And I, for 5 years until I became a circuit judge, did, I think, something like 150 cases, perhaps 300 or 400 hearings. They were informal in nature as hearings, and I treated it like an FDR, so I wouldn't continue to deal with the case once I'd finished a conciliation. We dealt with something like 150 cases with something like an 80% success rate. So those were cases which resolved, and very few, if any, ever came back in my experience. So there was a very low attrition rate. And as I say, that we were focusing over perhaps 1, 2, or 3 or 4 sessions on the relationship and how it might be improved, and trying to find solutions to the problem that the parents had. I need to say safety first always, and that's really important. I did not do conciliations, would not do conciliations in cases of serious domestic abuse. But I remember Dame Butler-Sloss saying a long time ago that there is a different spectrum around domestic abuse. Some of it is very much situational, around separation, what one might call bad behaviors around separation, which may be inevitable, but are not endemic controlling coercive behavior. But if there's a pattern of controlling coercive behavior going on, then it's very difficult to conciliate, as it's difficult to mediate. And one has to be very much aware of safety when identifying cases which are suitable for this process. And what it aims to do is to help parents by finding solutions to exercise their parental responsibility rather than submitting to state interference. And that's a distinction that Baroness Hale was very keen to put forward. And it is about giving parents the space in a more informal setting than a court hearing to set out their worries, their anxieties, what they think should happen, how they think they can help found solutions, work with the other parent. My experience is that private law cases are nearly always about a form of control. And I don't mean abusive control, I mean situational control. It's about parents who are trying to regain control over their own lives and over what happens to their children. And in doing that, they involve other agencies like lawyers, CAFCAS, the courts, to try and control the situation. Because I keep saying to parents, you have no control over what other people do. The only thing you can control is what you yourself do and say. And by behaving well or better, you can influence the other parent to the good. You can rebuild a level of trust that enables good co-parenting. And that's really what one's looking for within the conciliation process. And if you can achieve that, then you reach more sustainable and better outcomes, because you don't just address the where and the when and the how, you address communication and how we're going to do this and how we're going to talk. And it becomes more flexible. The court orders can tend to be inflexible. People wave them around saying, you've got to do this, you mustn't do that. And people think, I've got a court order, we've got to comply with it. In order to change it, we've got to go back to court. Outcomes that involve perhaps a parenting plan using the CAFCAS template can be much more flexible to meet children's developing needs. And onto the last slide, I think. So it focuses, I said already, on the building blocks. Trust and confidence is an essential thing to address. It helps to build, I think, empathy. It's an opportunity to say to parents, as I've said to you, what the impact of parental conflict is. And I do say that, and I give them the slides which I've prepared from the Harold and Sellers research. And it's an opportunity to identify and signpost professional support to other things like mediation, separated parenting courses, family conflict, and so on. You might ask the question, and I don't know if anybody has asked the question, what's different between that and mediation? I'm not a mediator, I'm not an arbitrator, but it is, I think, more directive. I tend to say to parents how it is as I see it, rather than just allowing them to discuss and try and reach resolution. And it does also involve an element of early neutral evaluation, which is the other benefit. I can say to parents, this is what is likely to happen if it goes to court. I can dispel unreasonable expectations, can manage better for them what they can expect from the court, what the court can do, and indeed what the court can't do. Many people think that the court has much greater power than in fact it does. So there we are. That's really what I wanted to say about conciliation. I think we're nearly at 5 minutes away from our deadline, so I've got to stop now, I think, and allow some time. I think I'm at my last slide. No, not quite. Just the last point. I think this is the last point. About early neutral evaluation, it's indicative and non-binding, but it might establish the platform for more informed discussion and negotiations. And you may think, well, it does add an extra layer of cost, but if it can avoid court litigation, it avoids not only the cost of litigation in financial terms, but also the huge emotional cost for parents and their children of going to court. And that really is an incalculable saving for a family. So I think that is the last slide. It is. So I shall stop sharing and hand back over now to Luke to, I hope, compare any questions there might be.
Yes. Well, I've been a little busy in the chat by there were a lot of questions about some specific sort of TOLATA points, which I have been endeavouring to fire off as they've been coming in. But there were a couple of questions that were sent before today that Martin and I had an opportunity to discuss. So if you're okay with this, Martin, if you take the first one, I'll read it out and then you give your answer, and then I'll answer the second question, and that should take us probably to midday. Does that work for you?
Yes, I can't actually see the Q&As, but you go ahead and tell me what the question is.
These are ones we received before today. So
right.
The question is this: if on divorce the wife stays in the former matrimonial home or purchases a new home with husband retaining a charge on the property, should any improvements by a wife to the property be taken into consideration when the husband receives his share of the equity, or would that only occur if it's provided for in the consent order or financial remedies order?
If the order simply provides for a charge expressed as a percentage of value, and neither the order nor the charge itself go any further than that to deal with the question of improvements, then the husband in that situation is going to get the benefit of any improvements because the value will be the value of the house as and when the charge falls in. So it's very important, I think, in these cases to make sure that both the order and the legal charge reflecting it set out a mechanism by which any substantial improvements over and above maintenance and repair are properly reflected in the valuation, so that the wife in that situation gets due credit for those improvements before the charge is calculated.
Yeah, I agree entirely with that. I think you can get a similar provision, can't you, if the party stays in the property and continues to pay the mortgage. I often find I have some good luck saying, well, they need to be, you can pop something in the consent order that wife receives the benefit of the capital repayments of the mortgage when it comes time to divide the equity, for example, which I suppose there's no harm. You could do, as you say, something similar in the order with improvements, couldn't you?
Yeah.
Okay. And then the second question is why I vaguely skirted over costs in the body of my presentation, and the question which I will answer and I'll proffer to you for any additional views, Martin, which I'm sure are more sensible than mine. But it's as follows: are costs recoverable by an intervener if successful? And if so, what's the procedure and likely chances of success in recovering costs against another party in the FR proceedings? Well, in short, yes, they are. They are accepted proceedings for the no order as to costs rule. That was determined in Baker against Rowe in 2010. A person intervening. What was strange is, though, is that a person intervening in family proceedings, my understanding is that they're still in family proceedings, so that the CPR cost rules don't apply to the intervener, and it's still you still have to consider the factors in FPR 28.2, I believe. But because it's a clean sheet case, it's still the soft no order as to costs regime, which Lady Justice Butler-Sloss outlined in Gojkovic. So it might mean that you could convince the court more or less easily to move away from a costs order in an intervenor action when there'd be some sort of unfairness. But that's it's FPR 28.3, sorry, 28.3.7, and the factors within. But yes, it is certainly, if there's an intervenor, sorry, muted myself by accident then. If there's an intervenor action in the midst of FR proceedings, costs are on the table. So I always advise my solicitor clients to basically run two concurrent cost schedules. You've got your one for dealing with the intervenor issues and one dealing with the FR issues. And that way, if you're successful, you can make a claim for those, because it cuts both ways. If the intervenor loses, they could have to pay your costs. Martin, do you have anything to add to that rambling response?
No, safe to mention that I think the judgment in Baker and Rose starts by pointing out that the husband was 99 years old and the wife was 98. I think the suggestion was that they'd been waiting for the children to die before getting divorced.
Yes, different strokes, eh? That's what's one of the wonders of financial remedies, isn't it?
Yeah.
We get a window into these wonderful people's lives. So we've got a few more questions now, actually, in the Q&A box, but we're running out of time. So let me just see if there's any we can answer quickly. If a husband argues he has beneficial interest in a property legally owned solely by a third party, not the wife, would it be the husband who has to join the third party? Yes, I would have thought so. If he said, I don't know why he would say that, because in one sense it would probably be beating his, well, it's saying he's got another asset that he's entitled to. I'd have thought the wife would be saying he's got an interest in that other property. So that's I think that. I think
did see a question pop up, Luke, while you were speaking about when an intervener refuses to sign away a consent to removal of restriction, and what power does the court have in that situation? And an off-the-cuff answer would be that the court might have the same power, so as far as an intervener is concerned, as it might have to sign in place of a recalcitrant husband or wife to the transfer of a property.
Yeah, that was my. I had a dual view on that, because I thought if there's an order for sale from the court, then my view was that I thought that would probably supersede any restriction.
Yes, you might do it automatically.
But in the event that that wasn't happening for whatever reason, then I agree entirely. Apply to join them and get the court to sign on their behalf, or say a solicitor could sign on their behalf.
I think in that situation, then the question posed was on the basis that the intervener was already a party.
Yes. Oh, right. Yes. Yeah. Well, now we have, it's 12:01. So we have one further question, which it's a bit of a long one. So I tell you what, I will have a look at that and email it. Email a response to that after today, because I'm sure everybody has got a busy day ahead of them on Thursday. So sorry we couldn't get to all the questions within the time frame, but we will respond in due time. Okay, well, that's it. Thanks everybody so much for attending today. we have a couple of great 3PP events coming up. We've got another family law brunch on Thursday, the 30th of March. So pencil that in your diary. It's a financial remedies themed brunch hosted by Nick Davies and Natalie Bull. The subject's on interim maintenance and interim applications in financial remedies proceedings. And also, as Lucy is putting in the chat now, we're very proud to announce our inaugural private law and financial remedies conference, which will be at Birmingham Repertory Theatre. That's on 11th of May, I believe, but Lucy will jump in the chat and tell me if I'm getting that wrong. Really, really great speakers there from Chambers, and also we've got His Honour Judge Edward Hess attending to give a keynote address. It's going to be a really, really great way to get your yearly CPD built up, and no doubt it will be good fun all round, if private law children and financial remedies is your idea of fun. So thanks everybody again, and we'll see you next time.
Bye.